A very good evening to one and all present here. On behalf of the Wednesday Club and also on behalf of the Wednesday Club, I extend my warm welcome to all of you present here. We all know that technology has pervaded our lives and also the profession. In the field of litigation, every day we have begun to use our intellectual faculty to bring in more technology-driven evidence in connection with our draft. Can you come to the front and seat yourselves in the front rows? There is some space here.
Those in the back, there are a lot of empty seats here. Please help us out and fill it in. When the guests come, we don't want any gaps here. Please. Except for these two seats, everything else please. Please come forward.
A very good evening again to all present here. On behalf of the Wednesday Club, I extend my warm welcome to all of you here. And also to the distinguished speakers here. We all know how much technology has pervaded our daily lives and also our profession. Being in the field of litigation, every day we use our intellectual faculty to incorporate technology-driven evidence in our daily work. The advancement of technology is such that it is at such a pace that the legislation cannot catch up. Nor is it viable to keep on modifying legislation as per the changes in the technology. In the light of this, investigation agencies, including the police, lawyers and judges face a lot of challenges when handling with technology-driven evidence. One major challenge is preserving the integrity of this technology-driven evidence throughout the cycle of investigation, examination, and trial. This is the intricacy of computer networks makes this even more complicated. Nonetheless, this huge assortment of technology-based evidence ought to be made admissible into the legal processes by way of legally administered methods. Hence, it is indeed a challenge to collect technology-driven evidence, and even more challenging to make the collected evidence admissible. Also, if we look at the present relevant laws, it is clear that the standard of proof of authenticity and accuracy of technology-driven evidence is more stringent than is the case with the conventional non-technology-driven evidence. In this scenario, it is the need of the hour that we get some real input on electronic evidence and aspects relating to its authenticity. I know that our speakers require no formal introduction. However, the format of the program mandates, so I proceed. Honorable Justice K.Abraham Mathew is a former judge of the Honorable High Court of Kerala with over 35 years of experience in the legal field. Sir is particularly well known for his judgments in criminal law, evidence, bail jurisprudence, and procedural fairness. One among many of Sir's frequently cited judgments is that of Sharon versus John. All of you must be aware of it. 2018, Volume 3, KHC 725. In this judgment, the question regarding whether the accused is entitled under Section 207 of the CRPC to get copies of e-records was considered in detail and decided. Honorable Justice Abraham K. Mathew is also the former director of the Kerala Judicial Academy. He has always been passionate and committed to imparting legal knowledge through various training sessions at different fora. Senior Advocate Shyam Padman, sir, has over 30 years of extensive experience in the legal field. He is a designated senior advocate of the Kerala High Court, and he is the founder of Messrs. Shyam Padman Associates. He is widely recognized for his expertise in the fields of medical negligence, medico-legal compliance, consumer protection law, cyber law, digital evidence, and professional liability. He is a trusted legal advisor to several medical and professional bodies across India. He is also the author of the two-volume commentary, The Law of Consumer Protection, 4th edition, published by LexisNexis India. He is also someone who's committed to promoting academic excellence and legal awareness through legal webinars. Now, I invite Shyam sir to give the introductory insight into the topic.
A warm good evening to all of you, especially Abraham Mathew sir. It's very interesting to note that on the very same topic almost 1 year ago, almost a year ago, we addressed lawyers from Kasaragod to Malappuram in Calicut, same section 65B. The only difference was that there was more confusion than now. Not that the confusion has completely gone after the recent Supreme Court judgment, but still it remains as such. So friends, let us first dispel the notion that it is something new, something different, something that is something beyond my comprehension because some technical names, technology-driven terminology is being used. There is absolutely nothing like that. It's my first submission before this August assembly. What exactly is the topic we are dealing with? It is regarding certification of electronic evidence. As you all know, when the Information Technology Act came into force, or rather came about. Thank you. Yeah, this is far better. Am I audible? No, it's okay. Sound okay. The definition of digital signature was incorporated in the statute itself. Later it was amended, and that portion was shunted off to the schedule and made the statute, I'll say, technology neutral. Then it became electronic signature, and anything and everything could be incorporated into that. The issue that we are dealing with today is exactly, are we trying to say that by a certification the document is proved, or just it gets that minimum qualification to enter the portals of the court? And as you all know, what is evidence? Evidence is anything and everything not outside the court hall, but what is introduced into a court of law. Nothing else is evidence. So for the introduction or getting the door open, the only thing that can be done, I just cite one example. I file a suit wherein I produce a will saying that that will is fraudulent, it is concocted, it has not been prepared, or it has not been made by the so-called testator. I want it to be declared as null and void. So any suit, if I want such a decree, I can produce it, or anyway I have produced it. Someone else takes a certified copy of that from the court and produces it elsewhere and argues, I am not a party in that, saying that this is an authentic document. Why? Because it is a certified copy obtained from a court of law. I hope you get the drift, because that exactly is what exactly the topic that we are going to talk today, and nothing more. And before that, I will also ask one question which I have been asking myself quite a time, many a times, that is, can there be an illegal, immoral or unenforceable contract? Simple question. It's not gauging anybody's knowledge, or we are not into a quiz competition, kaun banega crorepati, kuch bhi nahi hai. So I'm just putting it across to you. Just think about each and terminology used. Can there be an illegal, immoral or unenforceable contract? There can be yes and there can be no's. I am not going for a poll or anything in that matter. But just imagine what exactly is the question posed. Can there be an illegal, immoral or unenforceable contract? So we go into the root how a contract is formed. How does a contract come into being? First is a offer. Once that offer is accepted, it becomes a promise. And if that promise is supported by consideration, it becomes a agreement. And only those agreement enforceable under law alone is a contract. So the essential prerequisite to get graduation from an agreement to a contract is it should be enforceable under law. So there can be illegal, immoral or unenforceable agreements, but never an illegal, immoral or unenforceable contract. Why I came to this topic is not to enlighten you on what exactly are the essential prerequisites or ingredients or rudimentary elements of contract, but in the concept of formation of an agreement or a contract, there is no concept of paper. It was later on put in because we human beings have this tendency that when faced in an uncomfortable situation to disown what we have said. So to make sure that it is there, it is reduced into writing, attestation is introduced, then the state said, why don't we make some quick buck out of it by having a registration fee, etc., things like that. Otherwise it is not there. The same thing, what is necessary for a transaction is an atmosphere or an ecosystem wherein few things are essentially secure. A secure transacting environment. That exactly is what is made available in the web-enabled technology, or rather in the internet or e-commerce platforms. So what is necessary is to have a signature and authentication by the person who certifies that this is my product, or this is something with which I can be identified with. That exactly is what is meant by. So what we'll have to do is few things. That is why I said that the basic concept of what we are doing. Number two is that what are the terminologies being used in this field which is regularly being used. For example, it is known as public key infrastructure outreach. That is, you got a private key and a public key. That is the basic concept of having this, what you call as digital signature, encryption only, nothing else. So what exactly it is? So immediately key conjures up a imagination in our mind. What is it? A key. Whereas then if I am to ask you that key to the answer in the question paper, is there any key coming in? It is only something that unravels or helps you to open something, nothing else. What is a signature? Is it the dynamics of your handwriting? Need not necessarily, because signature is only I signify my assent to that, or I accept that. So it's a nod of a head or even an X something. So that will take in few other things also. Your biometrics, iris scan, facial features, all these things. So all these different facets, if you look into it, and for that matter, I'll just conclude on this preliminary aspect and come to the topic by just saying that how a secure system is made enable. Only three things. Which are the three things? What I am, what I know, and what I have. What I am is the biometrics, my facial features, iris, etc., etc. What I have is the dongle, etc., etc. What I know is the password, etc. The different combination of these things brings about a secure working ecosystem. So a court of law will look into few things. What is the first question that is asked when a document is tendered? Which is the source, or is it coming from a trusted authority? Is it from a proper custodian? The same question will be asked here. So what I am trying to demystify is that whatever happens in the natural world or in our day-to-day affairs is what exactly is what that's happening in the web-enabled technology or electronic evidence, etc. Only thing is that terminology may be different, but the essential primary questions being asked by the court of law does not change. The same thing is being asked. How is it that you say that, for example, a document is tendered, the document is marked? Does that prove that document? Marking is not proving. It is only for the easy reference. Anybody who has got a grievance against it can poke holes into it by saying that it is not authentic. But it is admitted in evidence. So today's topic is relating to two aspects which has to be seen clearly separate and significantly different. Number one is admissibility. Number two is the contents or authenticity. To what extent does this signature? Now I'll just go through the evolution of law and then I'll leave the podium for sir. Some 30 or 30, somebody was saying 3 decades. It is in 1990 I started practice, so around 36 years ago when I started practice, what we usually used to carry was a bundle. That was the case bundle tied by a knot, of course, and we had a diary with us, so to note the dates and things like that. Now everybody flaunts a laptop, and at best the other thing that would be a instant charger or a power bank, and it has changed. The advocacy has changed, the way the court perceives. We have got video conferencing, everything. So with the changing times, the paraphernalia has changed, but the basic structure remains the same. So under the old Evidence Act or the new avatar of it, the basic requirement of law has not been changed. The procedural or the required procedural parameters alone changes have been effected, nothing otherwise. Now, what is the statutory framework? Section 65B of the Indian Evidence Act, which corresponds to section 63 of the BSA. The BSA came into force on 1st July 2024, replacing the Indian Evidence Act 1972 in toto. Section 63 retains the architectural core of section 65B, a non-abstained deeming provision that treats computer output as document admissible without production of the original, subject to 4 cumulative conditions concerning regular use, ordinary course of activity, proper operation, and the manner in which the underlying data was fed, while materially sharpening the certification regime. Nowadays, I don't know how many of you remember, the youngsters may not even, would not even have seen a carbon paper. Carbon copy we used to have. So it is, even nowadays we apply for a carbon copy. Even though carbon copy is not what is being issued by the court, we say that immediately for anything a carbon copy may be issued. There is no carbon copies, but Evidence Act took care of mechanically produced copies, etc. And what exactly is the distinction between primary and secondary? That distinction to a certain extent has now become, it is just like the twilight zone, neither day nor night, but one merging into the other. So there is where all the confusion rests. And the courts by different interpretations have tried their best to clarify that and also to create an environment, especially when Section 4 of the Information Technology Act says that anything that could be done using paper can be done using can be done electronically, and those things are admissible and acceptable and as good as paper thing also. Section 63(4) certificate now in two parts. Earlier there was a difference of opinion whether evolution is very beautiful. Usually we used to have just one statement saying that this is a true copy, just like true copy. Then they said it has to be in the form of an affidavit. Then the affidavit came in. Now at least we have a format. Earlier we didn't have which form it has to be. Everybody used to put it as they liked. Now we have got a certificate which is in two parts. Unlike the single certificate contemplated under Section 65B, Part A executed by the party in charge of the computer or communication device disclosing device particulars, make, model, serial number, IMEI or whatever it is, cloud ID, etc. And critically is the hash value of the electronic record. I am sure that all of you would know what a hash value or a message digest is. Or to simplify it, I will put it in this manner. We would have gone, all of you would have traveled in flights. So there is one counter in almost all the airports wherein if you feel that your luggage would get damaged, you can give it and they will wrap it with some sort of plastic or cellophane or some material, and so that your luggage will not get damaged. Here the signature is something like this. Your whatever matter you have written is getting wrapped or rather encrypted, and the beauty is that finally we get a message digest, and for it there will be a hash value. Unlike regular signatures which we use, whether it is a multi-million contract or whether it's a love letter, whether it's a check, whether it is an entry into a hotel ledger, same signature. Here the electronic signature or digital signature is content specific, and if there is any sort of compromise to it, it can easily be found out. So there is less chances of it being the material or compromise is there. Then the part B, which created all the problem, which is an independent expert certification authenticating the same record on technical grounds. The statute does not itself define who qualified as an expert for part B, but Information Technology Act got a special provision which says that who is an examiner of computer evidence. But does not, can we rely on the old Section 45, somebody who is having that typical knowledge, etc. And as Abraham Mathew sir used to say that even a mason is an expert because expertise in that field. It is not as if the certificate does not make you an expert. The expertise is that a person who has got the knowledge, the experience and expertise in that particular whatever be the issue in question. Now, the statute does not itself define who qualifies as an expert for part B, a gap that until very recently was a single largest source of uncertainty. Madras High Court said one way, and finally even the recent Supreme Court, I don't think, I'm sure that sir also will not have any dispute regarding that, completely give a quietus to the issue. Things are at large, and I'm sure that this August Assembly can put their brain onto it to get more clarity by assisting the courts to come to a better decisions, not that the other decision is bad in any manner. Single largest source of uncertainty under the new regime, and which the Supreme Court has now addressed without a conclusive ruling, I would say, in Pune Bar Association with the State of Union. That's all, we will all be discussing that. Now, let us just see the evolution. It all started with the Parliament attack case. That is State NCT of Delhi, National Capital Territory Delhi versus Navjot Sandhu, 2005, Volume 11, SCC 600, where it started. Held that electronic records would be proved through the general secondary evidence route under Section 63 and 65 Indian Evidence Act, and absent a Section 65B certificate, and there was no Section 65B certificate. This flexibility was later disapproved by as incompatible with the special non-obstinate character of Section 65B. Before we understand that, let us also understand one another thing. Even prior to that, technology, etc. used to be there. There were occasions when these sort of issues were faced by the court, not because of computer or web-enabled technology, nothing. Sound recordings were produced in court. Its authenticity, etc. were to be verified. How it has to be introduced, that was dealt with by different decisions, and how the modality was also there. Then came technology one by one. Number one was telex, telephone, instantaneous communication. The Contract Act went into complete turmoil because the status of contract, where the cause of action starts, where the contract is concluded. Even postage did create problems because I signify my assent and send it to the other party. The other person approves of it only at his end and puts it in transmission. So when does the contract come into being? All these issues could be easily, which I am sure that all of you are well aware, could be easily understood and addressed by evolving judicial thought. So I am sure that this can also be addressed by evolving the judicial thought and by the assistance of a very vibrant bar. Then came Anwar PV versus PK Bashir. A 3-judge bench held that Section 65B certificate is mandatory for the admissibility of electronic evidence in the nature of secondary evidence, and that Navjot Sandhu, insofar as it held otherwise, did not lay down the correct law. Then an electronic record by way of secondary evidence shall not be admitted in evidence unless the requirements under Section 65B are satisfied. Thus, in the case of CD, VCD, chip, etc., the same shall be accompanied by the certificate in terms of Section 65B. Then came Shafi Muhammad. Anwar PV is 2014, Volume 10, SCC 473. Then came Shafi Muhammad versus State of Himachal Pradesh, 2018, 2 SCC 801. A 2-judge bench carved out an exception where the electronic records producer does not have control over the device from which it originates. The requirement of a certificate would be relaxed in the interest of justice. This directly conflicted with the mandatory language in Anwar PV and generated 4 years of inconsistent High Court practice. We had at least 16 to 17 decisions without exceptions which talked this way or the other way, and it was a time when a judgment would be rendered. It would be something more or less like show me the face and I'll show you the rule. Then came Arjun Pandit Rao case, that is 2020 Volume 7 SCC 1. A 3-judge bench resolved the conflict authoritatively. The court held the Section 65B4 certificate is a mandatory condition precedent to admissibility without exception. Oral evidence, however credible, cannot substitute for the certificate. Where a party generally cannot obtain the certificate because the device is not in its power or control, the remedy lies in seeking a court direction compelling protection, not in dispensing with Section 65B altogether. And as a matter of practice, certificates should ideally be filed with the charge sheet so that the defense can access to them at the stage of disclosure under Section 207 CRPC. Oral evidence in the place of such certificate cannot possibly suffice as Section 65B4 is a mandatory requirement of law. Then Sonu. Sonu is 2017 8 SCC 570 and Ravindra Singh Kaku also, that is in 2022, both Supreme Court judgment. These decisions enforce certification strictly at the trial stage and hold that an objection as to non-compliance with Section 65B, 63 must ordinarily be raised before the trial court. A party does not object at that stage cannot, save in exceptional circumstances, raise the point for the first time in appeal. As you all know that marking objection has to be raised at the time of marking unless and until it is inherently or otherwise is not admissible. If you give waiver is also possible, but not when the document is otherwise not at all admissible. There is no question of that. Then recently in 25-26, I'll conclude by just referring to those decisions. The law under the BSA takes shape. Since July 2024, courts have to work out largely without express statutory guidance how the Arjun Pandit Rao line of authority translates onto the 2-part certificate. We had another problem. Arjun Pandit Rao was relating to the old 65B, wherein we didn't have this bifurcation of part A and part B. Now, how it is to be done? It was dealt with by, I just referred to 3 judgments. 3 decisions I'll take in 13 months deserve close attention. Number 1 is Alukas Jewellery versus Anil. That is decided by our court on 17/7/2025. The Kerala High Court reiterated consistently with Sonu versus Haryana line that the absence of Section 63 or 65B certificate is only a curable defect and that an objection on this ground relates only to a mode of proof issue rather than to the inherent inadmissibility of the record itself. The decision keeps alive an unresolved tension already latent in Arjun Pandit Rao. The Supreme Court there treated the certificate as a mandatory condition precedent to admissibility, yet the appellate waiver rule in Sonu presupposes that the defect is curable and can be waived, a characteristic more commonly associated with mode of proof objection than with inherent admissibility. Counsel should note that this ambiguity, it was reiterated that if anything has been rendered more consequential by the 2-part certificate under the BSA. Then R versus B, Madras High Court, that is the one that was later referred to by the Supreme Court. And the Madras High Court, that is held that Part B of Section 63(4) Schedule Certificate, the expert certification could be signed only by the examiner of electronic evidence. That is, when I mentioned that in the IT Act, there is a provision for examiner of electronic evidence. It more or less relied on the principle of the special governs the general, saying that when there is a special provision embedded in the Act itself, then why do you look elsewhere and how can you introduce other persons as an expert? Notified under Section 79A of the IT Act, Information Technology Act, given the very limited number of such notified examiners nationally, hardly 10 or 12, I believe. This reading threatened to make compliance with Part B practically unattainable for the ordinary litigant and was the subject of constitutional challenge decided by the Supreme Court in May 2026. That is the recent decision. When both of us addressed the audience last year, this decision was not there. So, Pune Bar Association versus Union of India, that is the decision in Writ Petition Civil 599 of 2026, decided on 22/5/2026. At present, the single most important pronouncement on Section 63 BSA, a three-judge bench disposed of a writ petition filed by the Pune Bar Association challenging the constitutional validity of Section 63(4) BSA and its schedule as manifestly arbitrary and excessively burdensome. We have our own, I was discussing with sir before this presentation, so we have our own reservation, but the judgment is welcome because it is a progressive step towards understanding the nuances of this particular provision and the confusion created by divergent and varying decisions. The bench framed two issues for determination: whether Section 63(4) BSA and its schedule are unconstitutional as arbitrary or excessively burdensome, and secondly, whether Part B of the certificate can be signed only by Section 79A notified examiner of electronic evidence, as the Madras High Court held in R versus B, which I mentioned earlier. On the constitutional validity, the court upheld Section 63(4) in its entirety. It observed that electronic records are particularly vulnerable to alteration, mutation and modification, affecting their authenticity, integrity and evidentiary value, concerns that the court noted have become more significant with developments such as artificial intelligence and deepfakes technology. I can become a singer, swimmer, and I just saw Messi as Vadakan Veeraganda, Mammootinte adeyamari thanne varunnu. You cannot identify the difference. To such deepfakes have reached, and hash value of an electronic data is synonymous with an electronic fingerprint and provides a sure way of identifying the verifying data. The court further held that the expert certification under Part B provides an additional layer of authenticity to secondary electronic evidence, and the Section 63(4) has a clear and rational nexus with the object of the law and cannot on that footing be regarded as arbitrary or unreasonable. This is in effect a constitutional imprimatur on the dual certification model. Now, on the second issue, who may sign Part B? That is the issue with which we are more concerned. The court gave practitioners real, if provisional, relief from Madras High Court's restrictive reading. Examining Section 39 BSA, the court noted that subsection 1 recognizes generally the relevance of opinions of persons with special skill in science, technical fields or otherwise, while subsection 2 specifically treats the opinion of a Section 79A notified examiner of electronic evidence as expert opinion for electronic or digital information. Crucially, the court observed that Section 39(2) is not prefaced by a non-obstante clause excluding subsection 1. That is the way in which the court approached it. Reading the two subsections harmoniously, the court held that apart from a notified examiner, a person possessing special skill and expertise in computer science or cyber forensics may also qualify as an expert competent to sign Part B, provided the court is satisfied that expertise on the basis of unimpeachable material. However, and this qualification matters, since the bench was not admitting the petition or issuing notice to the Union of India, it declined to give a conclusive ruling. It clarified that the Madras High Court's finding in R versus B shall not be treated as a binding precedent. So that restrictive or reading the statute as it is and saying that only such and such person has now been read down and clarified. The practical consequences would be this: until a definitive ruling emerges, we will have to tender electronic evidence wherever feasible, with if possible under a 79A notified examiner for Part B, since this route is now judicially unimpeachable. Where none is reasonably available, a person of demonstrable computer science or cyber forensic expertise may suffice. But the burden of establishing that expertise on unimpeachable material will fall squarely on the party tendering it. Then again, it is opening of another Pandora's box, wherein we'll be put to task to prove that my expert is an expert. So this in short is the legal arena, or rather the landscape wherein now we stand. Whether there is sufficient clarification or not is yet to be decided by the different decisions that would be rendered, but restricting or trying to get this very scarcely available 69A experts is now being dispensed with. So maybe we'll be, I don't know whether SIDAC or some other institutions would come forward to certify things, because they are even otherwise hard pressed for time and resources in doing other cyber forensic activities. Then we may have to get, of course, subject to what sir has also has to say, I'd say that not much of a clarification has come, and the confusion as it stands yesterday even stands today, and during this deliberation we will also try to arrive at some sort of distilled thoughts on this subject. So friends, let me just conclude on this preliminary presentation of submissions and request Abraham Mathew sir to continue.
First of all, let me express my gratitude to the Wednesday Club office bearers for giving me this opportunity. Many faces are familiar, but some are not familiar, because I left the High Court in 2019, and seldom I come to High Court for any purpose. I came here after my retirement for taking this vaccination. And once in the auditorium there was a program by the advocates. So I belong to the old generation, but many of you belong to the new generation. And now there is an interface between law and technology. And we all know that our courts, including the Supreme Court, lag behind this science or scientific knowledge at least by 20 years. 20 years. So we take time, because unless a case reaches a Supreme Court or High Court, the court cannot pronounce a verdict. So the facts should be before the court. Somebody should bring the facts before the court. So the problem is that we always lag behind. When this DNA profiling came, the question was whether that is admissible under section 112 of the Indian Evidence Act, to prove that there was no access between the husband and wife, or the man and the woman. Anyway, it took much time for the Supreme Court to say that that is not the ordinary rule. DNA also can be present in the service, is science. The court cannot be blind to the advancements in the science and technology, and that also can be made use of by the courts. But some conditions are there. So actually what happens is that we always, advocates, we find it very difficult to deal with law which is based on technology. So I face it in a worse way, because I belong to the old generation. And when we deal with these questions, any question, the members of the legal profession, we must always ask three questions: what, how, and why. It may not be difficult for you to get the answer to the first or even the second question, what and how. But the third question, it may not be possible. Sometimes even these treatises may not give you the answer. You'll have to find it out on your own from your experiences. So let us now try to analyze these provisions and the law regarding this electronic evidence. As we all know, there are 4 classes of evidence now. First is oral evidence, the second is documentary evidence, the third is electronic evidence, the phrase used in section 39(2). There only you will find this particular term electronic evidence. The last one is material evidence. Material evidence. So this evening we are only concerned with electronic evidence. So unlike the Indian Evidence Act, electronic record, there is no term as electronic document, there is only electronic record. Electronic record comes within the definition of documents. But not only electronic records, something more is there. That is the digital records. Digital records. Subsection 2 of Section 2 Evidence Act says that any term which is used in this act but not defined, the meaning will have it will have the same meaning as assigned to them in BNS or BNSS. So let's first look at the definition of electronic record. You will find in Information Technology Act. Information Technology, BNS or BNSS. These are the 3 statutes referred to in subsection 2. But when we come to see section 61, section 61 says that the electronic record and the digital record are admissible as if they were documents. It's not necessary because they declared that they are documents. It's not necessary. But provided this is its admissibility is subject to section 63. So section 61 makes it admissible. It will treat it just like an original, but is subject to section 63. 63 exclusively deals with secondary evidence of electronic records. But there is no mention about digital record in section 63. Section 63. So the first thing is that digital record, though it is mentioned in the act, it is defined neither in this act nor in any other acts. So there is a confusion what is an electronic record and what is digital record. There cannot be any confusion what is an electronic record but what is a digital record. But as we all understand it, as some experts have told me, digital record is nothing but conversion of a physical record into an electronic record. We digitalize our records in the High Court, all records. So then it will be called a digital record. Anyway, it does not find a place in section 63, though it finds a place in section 61. Then what happens? There is no means to prove secondary evidence of digital records. There is a lacuna in the act. At the same time, though it is not mentioned in section 63, you again find it in the schedule. So in section 61 and section 63 you will find, even the definition you will see, digital record, but it is not found in section 63. So that is a lacuna in the, or that is the drawback in the drafting of this provision. So let's first understand what is to be produced. Whenever we produce documents or anything, the question before, especially in the case of documents, the question before an advocate is what should be produced and what is the effect of producing such thing. These are the 2 questions we have to ask ourselves. The first thing is, as in the case of ordinary documents, conventional documents, an electronic record also may have primary evidence and secondary evidence, just like any other document. It has primary evidence and secondary evidence. So primary evidence is defined, you can see in section 57. So the ordinary rule in the case of documents is that primary evidence should be produced. And exception is the secondary evidence. That is the ordinary rule. And when we come to the electronic records, there are some cases where you cannot produce primary evidence at all. That has been dealt with by the Supreme Court in Arjun Pandit Rao's case 2020 Volume 7 SEC 1. The Supreme Court said that in some cases the party is not even able to produce the original. That is the primary evidence, especially in the case of this network. then computer system, computer network and computer system, a party may not be able to produce the original, except in that cases. In every case, a party is able to produce primary evidence and secondary evidence. If primary evidence is produced, who can prove it? Because production, as we all know, there are certain stages in the life cycle of a document in a court. The first is production. What should be produced? The second is how to prove it. How to prove it. These are the two questions we have to answer in the case of electronic records also. So in the case of electronic record, except in these two cases, that is computer network and computer system, a primary document, the primary electronic record can be produced. But the question is, what is a primary electronic record? So under the Indian Evidence Act, there was no such provision, particular provision regarding electronic primary evidence of electronic records. But now section 57, there are some explanations to it. These explanations 3 to 7, these deal with primary evidence of electronic records. So what is the role of advocates? What is the role of advocates in producing this primary evidence? That is the question we have to find out first. And when we come to section 57, we can see this explanation 4 to 7. So I will just read one explanation. Where an electronic record, digital record is created, stored, and such storage occurs simultaneously or sequentially in multiple files, each such file is a primary evidence. This is almost just like the old Indian Evidence Act, the old provision in the Indian Evidence Act, that is by a uniform process. It is akin to it, a mechanical process, akin to it, almost like that. So a carbon copy, as Shyam said, carbon copy, though we call it a carbon copy, in the eye of law, it is primary evidence. Primary evidence. So the party need not explain non-production of the original. That is it. So the other three explanations, 4 to 5 to 7 also are there. So all these explanations contain some conditions. Especially when we come to explanation 6, which stands on a different footing from the other three explanations, because this is the explanation which exclusively deals with a video recording, where a video recording is simultaneously stored in electronic form and transmitted, broadcast, etc. So what is the role of advocates? These conditions, time is very short for me, so I will say that there are conditions in it. So what is the significance of this primary evidence? In electronic records, what is the significance of the electronic or primary evidence? The significance of the primary evidence is that, as held in Anwar versus Bashir, subsequently by the Pandit Rao, Origin Pandit Rao, the significance of primary evidence is that you need not produce a certificate under section 63(4). This is the significance. So if you prove that it is a primary evidence you have produced, then it need not contain a certificate. That is the only difference it makes. No difference it makes. So what is your role in it? So if you do not prove that it is a primary document, primary record, primary evidence, you will have to produce a certificate. That is the requirement of it. So to prove that it is a primary evidence, you have to first prove the existence of the conditions mentioned in section explanations of 4 to 7. So unless these conditions are proved, it will not be a primary evidence. So in the case of a carbon copy, you have to first prove what? That it was made by a uniform process using a carbon copy. Then only it attracts this primary evidence, the definition of primary evidence. Likewise, in the case of electronic record also, unless you prove the existence of the conditions mentioned in explanations of 4 to 7, it will not be treated as a primary evidence, even though it is a primary evidence. So the role of advocates is to prove existence of the conditions. So let us first see explanation 4. Where an electronic or digital record is created or stored and such storage occurs simultaneously or sequentially, in multiple files, each such file is a primary evidence. So what are the conditions? The first condition is that they were created, that or stored should be read as created and stored, because without creating it, you cannot store it. Unless you create it, you cannot store it. So it should be read as, in my opinion, it should be read as created and stored. Otherwise, there is a meaning in it. Mere creation, it does not exist, because it will be erased from the system itself. So what are the conditions you have to prove before you tender this electronic record as a primary evidence? You have to prove that this was obtained or taken from a file which was produced in, that is, multiple files, and one of this, what you have produced is one of those files, and they were produced simultaneously or sequentially. So unless you prove through the particular person who is competent to prove it, the person who produces it, that it was produced simultaneously, created and stored simultaneously or sequentially, it will not be considered a primary evidence. That's the problem with it. So the advocate who produces it should first prove that these conditions exist in case. That is, it was produced in multiple files, that is created and stored simultaneously or sequentially. Okay? So just like a carbon copy. So as you all know, under old section 136, now section 141 BSA, if proof of one fact depends upon proof of another, the second mentioned fact must be proved first. That is the law in it. So first you have to prove that these conditions exist. Then you tender it. So you have to prove through your witness that these conditions exist. Otherwise, it will not be treated as a primary evidence. That is the problem with it. So if you fail to prove it, it will be considered a secondary evidence, and you have to produce a certified copy. You have to produce a certificate as mentioned in section 63. When we come to explanation 6, where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transmitted to another, each of the stored recording is primary evidence. This is the only explanation which applies to video recording. As we all know, I am told that this is there is a live streaming of this program. Suppose I make a defamatory statement in the course of my discussion. The defamed person, how can he prove it? How can he prove it? The answer you will get in explanation 6. Time is very short. സാധാരണ ഞാൻ പറയുന്ന ഒരു എക്സാമ്പിൾ ഉണ്ടത്. അത് വളരെ ചുരുക്കത്തിൽ പറയാം. നമ്മൾ പണ്ടെല്ലാം ഫോട്ടോ എടുത്തിരുന്നെങ്കിൽ എന്ത് ചെയ്യണമായിരുന്നു? ഫോട്ടോഗ്രാഫറെ വിസ്തരിക്കണം, നെഗറ്റീവ് വിസ്തരിക്കണം. ഇല്ല, ഇപ്പം നെഗറ്റീവ് ഇല്ല, ഒന്നുമില്ല. എല്ലാം വേണം. അയാളെ വിസ്തരിക്കണം, പ്രൂവ് ചെയ്യണം, ഇതെല്ലാം ഉണ്ടായിരുന്നു. Now it is not necessary because there is no, it's only digital photo now. Okay. Suppose a funeral takes place in a house. The children are not here. The father is dead. And one is in America, the other is in Europe, then the other is New Zealand, the other is in Africa. All these 4 children are elsewhere, in other countries. And they are informed that your father is dead. And they will just have a discussion. Video conferencing is there. And they say, immediately we have to go because our father is dead. Then one of the children says, why should we go? The other one says, it is our duty to give him a decent burial. It's a statutory duty, constitutional duty. Not only that, it is our moral duty also. So he is entitled to a decent burial. The other man says that to give him a decent burial, why should we go? We can make some arrangements better than the funeral we may give them. How? എന്താ ഇതിന് മറുപടി? ഈവൻ മാനേജ്മെൻറ്റ്. അങ്ങനെ ഈവൻ മാനേജ്മെൻറ്റുകാരെ ഏർപ്പാട് ചെയ്തു കഴിഞ്ഞപ്പോഴേക്ക് ഫ്യൂണറൽ ഇവിടെ നടക്കുന്നു. പൈസ എല്ലാം നേരത്തെ അങ്ങ് കൊടുത്തു കഴിഞ്ഞാൽ 5 ലക്ഷം രൂപയും കൊടുത്തു അവർക്ക്. ഇതെല്ലാം കഴിഞ്ഞപ്പോഴേക്കാണ് ലൈവ് സ്ട്രീമിംഗ് ആണ്. അവിടെ ഇരുന്ന് അവിടെ എല്ലാം കാണുന്നുണ്ട്. 5 രാജ്യങ്ങളിലിരുന്ന് 5 പേരും മക്കളും കാണുകയാണത്. അപ്പോഴതാണ് ഒരുത്തം പറഞ്ഞത്, ഒരു കുഴപ്പം സംഭവിച്ചിട്ടുണ്ട് ഇതിനകത്ത്. ഇത് കരഞ്ഞത് മക്കളല്ല എന്ന് കണ്ടവർക്കൊക്കെ മനസ്സിലായി. കരച്ചിൽ ശരിയായില്ല. അപ്പോൾ നമുക്ക് ഒരു സൂട്ട് ഫയൽ ചെയ്യണം for refund of this amount. Failed. The event management failed. How will you prove it? That's the only question. How will you prove it? Because the videographer, the person who recorded it, is not available. He is not willing to prove it. How will you prove it? This answer you will get in explanation 6. If it is recorded, stored by these people in the other countries, that is sufficient now. The explanation 6. You need not examine the videographer. You need not bring the record in his custody. Instead, where a video recording is simultaneously stored in electronic form, transmitted or broadcast, or transferred to another, each of the stored recording is primary evidence. If they have stored it, the man in America has stored it there in his laptop, the other one in Europe, then that is sufficient. But this explanation you have to give first. The conditions you have to that was a streaming, this was a simultaneous broadcast was there, so it is a primary evidence. If you do not bring it out through your witness, it will be treated as a secondary evidence. So these conditions, this law is applicable to every explanation that is given here. Now we are coming to the effect of Shyam was telling about this effect of production of a document or certified copy, just like any other document. What is the effect of production of a certified copy in ordinary documents? As we all know, it is said that Supreme Court is supreme because there is no court above it. Not because what the Supreme Court say may be correct.
Not because it is not infallible.
Yes, infallibility is there, even in the case of Supreme Court. Okay? So, actually, you will see divergent views. Some Supreme Court judges say that mere production of a certified copy will prove the truth of it. That's sufficient. You just produce it. But other Supreme Court judgments say that no. The effect is just like producing the original, no other effect. Instead of producing the original, you have been given the liberty to produce a certified copy under section 76 of the Indian Evidence Act. So what about the electronic record, certified copy of electronic record? What is the effect of producing a certified copy? Is it necessary to prove the contents again? Is it necessary to prove that the contents is true? These are the questions. The effect is given in section 63(1) itself. See, section 63(1). It will be admissible, that is the computer output, is admissible in any proceedings without further proof or production of the original. It only dispenses with the production of the original, nothing else. He says that it is as good as production of the original. No other effect is there. It's not a better one. It's not a better one. And moreover, is further stated, production of the original as evidence or any contents of the original or the fact is stated there. So, it is as good as producing an original, nothing worse, nothing better. So, if the truth of the contents is challenged, the party should prove that the contents is true. This should not be overlooked. By merely producing an electronic record, you cannot prove the truth of it, provided the truth is challenged by the other party. If the truth is not challenged by the party, there is no question of proving it. Okay, this is the effect of this particular production of the original, production of the secondary evidence. Now we come to, I think we need not discuss this Arjun Pandit Rao, which followed P.V. and Worth, great extent. Arjun Pandit Rao says that section 63 is a code by itself, in the sense that you cannot look into any other provision in the BSA to decide the admissibility of a secondary evidence of an electronic record. That is the law now. Yes. Now, the question here is about the stage of production. There was some mention. What is the stage of production of a document? Electronic secondary evidence of this. In Arjun Pandit Rao again, many questions have been answered in Arjun Pandit Rao. If you read it carefully, you will get all these answers, I think. So, the ordinary rule is that a document should be produced in civil cases along with the pleadings, and later, if the court permits it, before the issues are framed, or later with the permission of the court. And in the case of police cases, it should be produced along with the police report, final report, and if it is a complaint case, with the complaint. Time aaya. Yes. Okay. All right. So, what is the stage of production? The Supreme Court take notice of the difficulty in getting a certified copy. Because suppose you purchase something from a department store and it is found defective and you want to file a case against this particular department wala, you cannot ask the department to give a certified copy because the system is with him. I want to prove a case against you, file a case against you, please give me a certified copy. Will he give it? This was the question that was raised in Shafi Muhammad. Shafi Muhammad, that's very difficult to get. It is impossible to get a certified copy from the holder of this, custodian of this device, because he will not give it to you. So, for that, the Supreme Court said in Arjun Pandit Rao, there are means to get a certified copy. How you get it? That's the question. How a party can get a certified copy which is not available to him. If the device is with you, you can certainly produce it. Then how can you produce it? That was the first question that was answered by the Supreme Court. The Supreme Court said that there are provisions in both CPC and Civil Criminal Procedure Code enabling a party to get a certified copy. So what is that? What is that provision? Or which is that provision? See, Pandallam Namala Parayumayirna court certificate to get a certified copy. Because if it is a public document, sometimes the village officer may not give you immediately a certified copy because you want to file a suit immediately. So what you will do, you will file an application before the court to direct the village officer to give you a certified copy. That is called court certificate. Angane practice yes, in Travancore it is called the court certificate. Court certificate. Under which provision of which law this is obtained? Okay, take the case of take a criminal case. The complainant wants to get a certified copy, electronic record, under section 63. How can you produce it? That is the question. See, old section 91, the present section 94 CRPC, BNSS, section 91 CRPC, section corresponding provision is 94 BNSS is that the court may order any person to produce a document. So you must file an application under section 94 BNSS to direct anyone, any other party, any person to produce a certified copy and you get it. And suppose he does not produce it, what will happen? That also you must know. It is not sufficient that you know how to get it. If he does not give it, what to be done? Can anyone say what can be done if he does not obey in criminal case? In criminal case, what can be done? Yes. Then there is a provision in CRPC, corresponding provision in BNSS also, section 349, which says that the court can proceed against him. He will be liable to be punished by the court immediately. After giving an explanation, opportunity to explain, then he can be punished by that court itself or by a regular court. So there is effective provision, both criminal law. When we come to civil law, again you can see in Order 16 or Rule 6 CPC. You may file an application before the court to direct him produce a certified copy. And if he does not produce it, again, the provisions are there, that is Order 16 Rule 10 CPC, that he will be proceeded against. His property will be attached, he will be sent to prison. Yes. So there are provisions, effective provisions in both civil and criminal laws to get a certified copy from any other person. So the Supreme Court held that it is not impossible. It is not impossible. You make use of that provision. That is what the Supreme Court held in Arjun Pandit Rao's case. Now we come to, so it can be produced at any stage, but the delay should not cause prejudice to the other party. That's all what the Supreme Court has said in Arjun Pandit Rao's case. Now we come to contents of certificate before that. Contents of certificate, or before contents of certificate, you can see this is the problem creating provision subsection 4. In any proceeding where it is desired to give a statement in evidence by virtue of this section, that is a certified copy, a certificate doing any of the following things shall be submitted along with the electronic record at each instance where it is being submitted for admission, namely identifying, etc., etc. Then, purported to be signed by a person in charge of the computer or communication device or the management of the relevant activities, whichever is appropriate, and an expert shall be evidence of any nature, etc. And for the purpose of this section shall be and so now the certificate has two parts. Schedule is given, part A and part B. The Supreme Court, it was brought to the notice of the Supreme Court in Pune Bar Association case that is unconstitutional because it creates a hardship for the parties. But the Supreme Court said that no such a hardship. There is a hardship in every case. There is no hardship. But I think if certain facts were brought to had been brought to the Supreme Court, notice of the Supreme Court, at least some modifications the Supreme Court suggested and some guidelines by the Supreme Court would have been issued till a modification is made by the central parliament. What is that? See, it is purporting to be signed by a person in charge of the computer, certificate by two parties, one who person in charge of the computer, and the certificate should be as prescribed in the format of schedule, right? So this section says that should be given, may be given by a person in charge of the computer. But what does the format says? See, part A. Part A. To be filled by the party. And says I. That means the format presupposes certificate by whom? Part A by the party. And this is what the Supreme Court has reiterated also. The party can give it. Party can give it. But the section does not say that party can give it. The section says that it shall be given by a person who is in charge of the computer. So the section or the schedule is not in conformity with the section. There is incongruity. How can the court, how can we explain it? It cannot be interpreted. Interpreted can be only by an amendment, can be rectified. I think the Supreme Court did not take notice of it in Pune Bar Association case.
The process is being certified.
Certified. It only said that merely because there is a hardship, it cannot be said to be unconstitutional. That is all what the Supreme Court said. How to get over this difficulty? There is no suggestion in the Pune Bar Association case. Now we come again to say what are the matches to be certified by a party. See, I have produced electronic card output, etc. taken following record since computer, storage media, DVR, mobile, CD, cloud, etc. etc. Make and model, color, serial number, IME. Who can give it? Who can give it? Honestly, who can give it? I think nobody here can give it such a certificate. It is not a question of mere difficulty. It's almost impossible for any party to give such document, such a certificate. The Supreme Court did not address this question. Now we come to expert. The meaning of expert also we have seen. Madras Bar Association held that expert means only under section 39(2). A person who is declared. There are two types of classifications or categories of experts. Persons who have been declared experts by statutes and persons who have not been declared experts by statutes. So what's the difference? Section 39 subsection 2 says that an examiner of electronic record appointed to the information technology, section 17A, is an expert. As rightly said by the Supreme Court, it does not mean that no other person can be an expert in this world. Anybody can be an expert provided he satisfies the conditions in section 39 subsection 1. Okay? So, but what is the effect of this declaration? What is the effect of this declaration is the question before us. The only effect of question or the difference between a declared expert, statutorily declared expert like this electronic records, standard electronic records, and the other experts is this. In the case of statutory declared experts, the party need not to prove that he is an expert. So it dispenses with the requisite of proving that he is an expert. You need not prove because the law says that he is an expert and nothing else. No other difference it makes. But in the case of other experts, the party has to first prove that he is an expert. Then only he is entitled to give an opinion. So in the case of all other experts, what happens? You have to bring that person before the court. You have to first give evidence in the examination chief, his qualifications, his skill, his practice, etc. Then he can give his opinion. That yes, this is a true copy. A certificate can be given. Is it possible for every person in this world to do it? How much money he has to spend?
And who will take the trouble of coming to court?
That is the problem. Every nook and corner you will get an expert. How can you know whether he is an expert or not? Merely because he has a degree in electronics, can you say that he is an expert? He has to prove that he is a skilled man. How can you do it? And who will come? You have to pay something to him to give a certificate. You give it. Then when it comes to the court, again he has to appear. If there is, will he take the trouble of coming to court to depose for this meager amount? Nobody will come. So practical difficulty means it is almost impossible for an ordinary man. For an ordinary man, it may not be possible to get a certificate from an expert. Then he comes here, gives evidence, money we are ready to spend, no problem. Then again it is hanging in the balance what the court will say whether he is an expert or not. If the court says that he is not an expert, what will happen? His case fails. So how much risk is there? How much risk is there? Is this the way in which a provision in a central act should be drafted? Unfortunately, these things were not brought to the notice of the Supreme Court. If this incongruity between this section and the notification, that itself would have tilted the scale. The Supreme Court said that yes, there is a difficulty in the administration of justice. We have to step in by the process of judicial activism, as in the Vishaha case. The Supreme Court would have issued some directions, guidelines, till a change is made in the law by the Parliament. That was not done because this was not brought to the notice of the Supreme Court. What was said in the Supreme Court is that it is difficult for a person to comply with it, so it is unconstitutional. Naturally, the Supreme Court that mere difficulty in getting this evidence is no ground to declare the provision unconstitutional. That is what the Supreme Court has said. So, I think again, in some cases this problem will arise and the Supreme Court will have to give an answer to this question, how to make this provision and the schedule go together. Yes. Now coming to the objection. There was a reference to Sonu versus State of Haryana. The Supreme Court said that even in the case of electronic record, if a document, electronic record happened to be admitted in evidence or without any objection, on the ground that does not contain a certificate, then that is the end of it. It cannot be challenged again. Because so far as the right of mode of proof is concerned, it can be waived, just like any other ordinary case. And in the case of electronic record also, so the Supreme Court said, Sonu versus State, there was some controversy. Some people said that it is it was before this BSA. No change. It is only mode of proof. Even in the case of electronic record, it's only a mode of proof. That is why it finds a place in section 63, not in any other chapter. It's only a mode of proof. So if the opposite party, the advocate, does not object to the marking of the document on the ground that it does not contain a certificate, then that cannot be raised later in the same suit or in appeal, in the same proceedings or in appeal or even Supreme Court. That cannot be. That is the law in the law of the land now. Now the question is, suppose he rightly mentioned it, the only provision, the only instance where you can raise that objection later in the case of ordinary document, which is the instance in which the only instance where you can raise that question, that is wrong admission of the document. Though it was inadmissible, it was admitted. The only instance where you can raise an objection is that the original itself is not admissible. If the original itself is not admissible, even though the certified copy is, even though a copy or electronic record, secondary evidence was admitted in evidence, that objection can be raised at any stage, even in the Supreme Court. That is the law. Because take a case like an ordinary document where it is a sale deed, but it is not registered. And if it is not registered, then what happens? The original itself is admissible. Because it can be effected, sale can be effected only by a registered document. So if an unregistered sale deed is produced, happen to be admitted without objection, then that question can be raised at any stage, even in the Supreme Court, because it affects the admissibility of the original itself. The same rule applies in the case of electronic records also. So we can conclude like this. This secondary evidence, proving a document or electronic record by a secondary evidence, is only a mode of proof. It's only a mode of proof. Unless the party who is entitled to object to it does not object to it on the ground that there is no certificate, he cannot raise that question again in the same proceedings or later, like a appeal. No. Then, since it is a mode of proof, it can be waived. There is no difference between an electronic record and any other documents. But this is subject to the law that if the original itself is inadmissible, the marking of secondary evidence of electronic record does not make it inadmissible. Does not make it admissible, merely because it is marked. So this is the law so far as admissibility of the secondary evidence is concerned. Then there was a mention about hash value. I am, as I told you, I am very poor in technology because I belong to the old generation. But as he rightly said, hash value means it gives a value to the contents, right? It gives a value to the contents. But ordinary document, we do not give any value to the document. It is not valued by anyone. What is the value of it? By counting one word, each section, etc. No. But in the case of electronic records, it is possible.
Correct.
That is called hash value. So the moment you create a document, the moment you complete an electronic record, its hash value is determined. And any change made to the document will reflect in the hash value. That is the significance of hash value. Suppose you added a comma, then there is a value for it. There is a value for it. So the total value changes. So this is the significance of hash value. Any change, there is a dispute. I don't know whether I am not able to say it. Merely because it is copied, its hash value does not change.
It will change.
It
will change.
Change. That is actually what I know. But some experts say that no, it will not change.
No,
I don't know why they say it.
Even
because
if
we are not technicians.
Open it twice or thrice.
The moment you open it, that is why when a copy is taken, it is a mirror image actually. Experts take not copy directly from it, but suppose I stand before this mirror and a photo is taken from the mirror without showing this camera toward me, that means it is a mirror image.
Correct.
It is just like that. A copy of an electronic record is taken by experts. They do not touch the original. Now we are coming to a very great important question. How can you get a certified copy of an electronic record produced in the case? How can you get? Suppose you apply tomorrow before the registrar. I may be given a certified copy of the CD. Take it as a CD. What the registrar will do? Can anyone say? This question was, ഒരു പുതിയ ജില്ലാ ജഡ്ജി സ്ഥലത്ത് വന്നു കഴിഞ്ഞപ്പോഴേക്ക് കോടതി വന്നു കഴിഞ്ഞപ്പോഴേക്ക് ഇതുപോലൊരു ആപ്ലിക്കേഷൻ വന്നു. for a certified copy of a CD produced by the police. I want a certified copy. Certified copy. അപ്പോൾ ജില്ലാ ജഡ്ജിക്ക് ഒന്നും ഒരു പിടിയും കിട്ടിയില്ല, സർട്ടിഫൈഡ് കോപ്പി CD എങ്ങനെയാണ് കൊടുക്കുന്നത്. അപ്പോൾ ശരസ്താരെ വിളിച്ചു, ഒക്കെ എക്സ്പീരിയൻസ് ഉള്ള ആളല്ലേ, വിളിച്ചു ശരസ്താർ ഇതെങ്ങനെയാണ് ഇതിൻ്റെ സർട്ടിഫൈഡ് കോപ്പി കൊടുക്കുന്നത്. ശരസ്താർ ഇറ്റ്സ് വെരി ഈസി, ഞാനിപ്പോൾ കൊണ്ടുവരാമെന്ന് പറഞ്ഞു. ശരസ്താർ നേരെ അങ്ങോട്ട് ചെന്നിട്ട് ആ ഫോട്ടോ കോപ്പിയറിലേക്ക് സാധനങ്ങൾ വെച്ചു കൊടുത്തു. എന്നിട്ട് കൊണ്ട് ദിസ് ഈസ് ദി സർട്ടിഫൈഡ് കോപ്പി, ദിസ് മേ ബി സർട്ടിഫൈഡ്, ദിസ് ഈസ് ദ ട്രൂ കോപ്പി ഓഫ് ദി CD. നമുക്ക് എന്ത് ചെയ്യാൻ പറ്റും? Because, as he rightly said, it can be mutated, it can be changed, any alteration can be made. How can the court certify it? This question was raised in only in one case before the Supreme Court. That is the Supreme Court, that was in 2017, AER 2000, Tarun Tyagi's case, AER 2017, Supreme Court 1136. The Supreme Court says that that is a how to give a copy. എങ്ങനെ കോപ്പി കൊടുക്കാന്ന് പറഞ്ഞാൽ cloned copy should be given. Is it possible for every district court to give a cloned copy?
Judge clone indi.
It's not possible. So as of now, there is no answer to the question. In ordinary case, how can you get certified copy? Taking a copy and writing on it that it is a certified copy, it is liable to be changed or altered anyway, anytime. So that's not possible. That question also is there. Now I will ask you one question. What is the effect of recently, you know, especially I am not loyal to any political party. I have no politics, though I have political opinion. I have no politics, though I have political opinion. Police excesses are there. Police excesses are there. Delhi, you see, Kerala, you have seen. And what is the effect of producing a videograph? What is the effect of producing a videograph? Yeah? What is the effect of it? A videograph is produced showing that the police officer beat him like anything. But the victim himself was declared hostile. The victim himself was declared hostile. How can you prove it? The videograph is there, it is marked. Its genuineness was proved. Then what is the effect of it? In criminal cases in future, this question will arise. I don't want to mention any incident which happened recently, but I have it in my mind. See, what is the effect of producing a photo of an incident? Photo. The only thing is a subject of proof, genuineness. It is proved. What is the effect of it? What is its probative value? That is the question. What weight you can treat? What is the nature of that evidence? Is it a substantive evidence? Is it can be used only for corroboration? What is its probative value? Certainly, these questions will come up in court in many cases in future, because everywhere you have CCTV. A thief committing this offense, there is a CCTV, no witness is there, how can it be proved? What is the effect of proving this CCTV? Genuineness proved. What is it? In the case of photograph, the Supreme Court said that it is a primary evidence of its contents. It's a primary evidence of its contents. Not only primary evidence, it is a direct evidence, and it is a substantive evidence of the fact contained in it. What does it mean? No other witness is necessary to prove it. The fact found in the photograph will stand proved by proving the photograph itself. It's a primary evidence, it's a direct evidence, it is a substantive evidence. What does it mean? It is just like a person witnessing it. It is just like a person witnessing it. And in V.V. Giri's case, the Supreme Court said that there is no difference between a tape, a statement recorded on a tape, and a photograph. They stand on the same footing. What does it mean? The Supreme Court said that it is a direct evidence, it is primary evidence, it is a substantive evidence. And videograph stands on a better footing. Because in tape, And in audio, you may not get pictures. But in the case of videograph, you get everything there. So, in my opinion, by proving the genuineness of the videograph, even if all the witnesses stand hostile, the prosecution can easily prove it. Because it is a direct evidence, it is primary evidence, it is a substantive evidence. So, for prosecutors, it will be easy now to prove these incidents like this police excesses. Okay. So, I think I can wind up because this is the only this much time I have been given.
So questions and everything.
Questions you may ask, and our Shyam will answer it.
Sir,
Yes. See, I told you that my knowledge in technology is very poor, very poor. And only after demitting my office in the High Court, WhatsApp പോലും എനിക്ക് കിട്ടിയത് അതിന് ശേഷമാണ്. അതിലൊരു വാട്സപ്പ് പോലും ഇല്ല, ഇപ്പോഴും യൂട്യൂബിലും ഇല്ല, ഒന്നുമില്ല. ഞാൻ അല്ല ഇതിലൊന്നിലും ഒരിടത്തും ഇല്ല. എനിക്ക് അക്കൗണ്ട് ഇല്ല, ഒന്നുമില്ല. യെസ്.
Questions?
നമ്മൾ പലപ്പോഴും പറയാറുള്ളത് പോലെ രണ്ട് കൂട്ടര ക്വസ്റ്റ്യൻ ചോദിക്കാത്തവർ, ഒന്ന് എല്ലാം മനസ്സിലായവർ, മറ്റത് ഒന്നും മനസ്സിലാകാത്തവർ. നിങ്ങളൊക്കെ ആദ്യത്തെ ഗ്രൂപ്പിൽപ്പെട്ടാണെന്ന് ഞാൻ വിശ്വസിക്കുന്നു. യെസ്. CCTV യെ സംബന്ധിച്ച് there is one ruling of the Supreme Court that is evidentiary value, that it is also certificate necessary. CCTV, in the case of CCTV also certificate is necessary. That is Chandrabhan Sudham Sambu versus State of Maharashtra, AR 2025, Supreme Court 1103. But remember, as I think she mentioned it, one decision of mine, the same thing can be treated either as a material object or as a document. Same thing. Because suppose I hit Shyam with this book. What is the significance of this book? It is a weapon. It is used as a weapon. It's a material object. And in the case of material object, I need not prove that who wrote it or who is the author of it. Nothing. Likewise, in the case of electronic record also, it can become a material object or it can be treated as an electronic record. If you prove it as an electronic record, if it is necessary for you to prove the authenticity of it, then that means you have to prove it. Authenticity. But in the other cases, just like the contents of an electronic record is obscene and it was seized from an accused, then you need not prove, there need not be a certificate. Why? Because it is produced not as a electronic record but as a something material object he was found to be in possession of. Because a person, the possessing an obscene matter itself is an offense. That's all what the Supreme Court says. Sorry, the prosecutor says. See, he was found in possession of this thing. The court may draw an inference. So this is the difference between, even in the case of electronic record and document, the law is the same. It can either be considered a document or a material object depending upon the purpose for which it is sought to be produced. Yes.
I got a question from one of the persons who was watching it live. So, how are email communications to be marked as per section 63 of BSA? Should it be from the server of the relevant service provider, example Gmail, or can a printout of email downloaded into a computer device be used with certification under 63.4?
Yes. See, what is the nature of a printout in electronic record, the law of electronic records? What is it called? There is a term used for it. No, there is a term, legal term used for it. No. It is a computer output. Computer output. Something which comes out of a computer is a computer output. Okay? It can be in the form of another electronic record, CD. You are copying it in a CD. You are copying it in a pen drive. And same you are getting in a printout also. All these together are called computer output. Computer output is what? A secondary evidence. And in the case of a computer output, secondary evidence means the two conditions are to be satisfied. The conditions has to the contents, the condition has to the computer. Okay? So it can be proved by producing the printout, no doubt. But so far as the email is concerned, there is a specific provision. Which is that provision? ഇത് പോലീസുകാർക്ക് പറ്റുന്ന ഏറ്റവും വലിയ അബദ്ധങ്ങളിലൊന്നാണ്. What is the special rule of evidence as to a email? Yes. There is a specific provision. Section 90. Older sections 88A. Presumption as to electronic messages. The court may presume that an electronic message is forwarded by the originator, Anchala, through an electronic mail server to the addressee to him. He got it. Message purpose to be addressed corresponds with the message as fed into the computer for transmission. അപ്പോൾ കമ്പ്യൂട്ടർ നമ്മൾ പ്രൊഡ്യൂസ് ചെയ്ത് ഒറിജിനൽ പ്രൊഡ്യൂസ് ചെയ്ത് നമുക്ക് കിട്ടിയ ഒറിജിനൽ ഹാജരാക്കിയാൽ എന്ത് പറ്റും? You produce the original itself. See, this is what I got from him. Then it's an original one. Okay? So the question here is, suppose it was a sin, especially criminal cases, നമ്മുടെ terrorist activities. This question I think it arose in that priest who died in the jail, Stan Swami. അതിൻ്റെ അകത്ത് പറഞ്ഞിരുന്ന അലിഗേഷൻ അയാൾക്ക് മാവോയിസ്റ്റുമായിട്ട് ബന്ധമുണ്ട്, നക്സലൈറ്റ്സുമായിട്ട് ഇമെയിലിൽ നിന്നെല്ലാം കാണാമെന്നുള്ളതാണ്. ഇത് വെച്ചാണ് അദ്ദേഹത്തെ ജയിലിൽ. ദിസ് പ്രൊവിഷൻ വാസ് നോട്ട് ബ്രോട്ട് ടു ദ നോട്ടീസ് ഓഫ് ദ സുപ്രീം കോർട്ട് ഓർ ദി കോർട്ട്. ദിസ് സെക്ഷൻ സേസ് ദാറ്റ് ദിസ് വാസ് എ സിമിലർ പ്രൊവിഷൻ വാസ് ദർ ഇൻ ദ കേസ് ഓഫ് ടെലഗ്രാഫ് മെസ്സേജ് ഓൾസോ. ഇല്ലേ? അതിൻ്റെ അകത്ത് എന്താ പറഞ്ഞിരുന്നത്? ഞാൻ സാധാരണ പറയുന്ന ഒരു എക്സാമ്പിൾ ഉണ്ട് അതിൻ്റെ അത്. ഇതാണ് അതിൻ്റെ അത്. ഒരു വീട്ടിൽ 2 പെൺകുട്ടികളുണ്ടായിരുന്നു, മക്കൾ. അപ്പോൾ ആ പേര് ഇവിടെ ആരും ഇല്ലാത്തതെന്ന് ഞാൻ വിചാരിക്കുന്നത് ബീനായെന്നും മീനായെന്നും വിചാരിക്കുക. ബീനായെന്നും മീനായെന്നും. ഈ 2 പെൺകുട്ടികളും ദൂരെ ഒരു സ്ഥലത്ത് ഹോസ്റ്റലിൽ നിന്നാണ് ജോലി ചെയ്യുന്നത്. ബീനയുടെ കല്യാണം കഴിഞ്ഞ് ബീനയും മീനയും കൂടെ തിരിച്ചുപോയി. ഒരു കൊല്ലം കഴിഞ്ഞപ്പോഴേക്ക് വീട്ടിലേക്ക് ഒരു മെയിൽ വന്നെന്ന് വിചാരിക്കുക, അല്ലെങ്കിൽ ടെലഗ്രാം വന്നു. അതിൻ്റെ അകത്ത് ഇന്നാ പറഞ്ഞിരിക്കുന്നത്, മീന ഡെലിവേർഡ് എ ബോയ്. ഇത്രേ ഉള്ളൂ, മീന ഡെലിവേർഡ് ബോയ്. ഇവിടെ ആകപ്പാടെ വിഷമായി പേരൻസിന്. എന്ത് പറ്റി? കല്യാണം കഴിച്ചാരാ? ബീനയാണ്. ഹോസ്റ്റൽ വാർഡൻ അയച്ചിരിക്കുന്നത് അല്ലേ? ഹോസ്റ്റൽ വാർഡൻ സെൻറ്റർ മീന ഡെലിവേർഡ് ബോയ്. ഇവർ ഹോസ്റ്റൽ വാർഡനെതിരെ കേസ് കൊടുത്തു. What is the evidentiary value of this email or say older telegram? What is it? It was sent by, is there any presumption? ഇത് എല്ലാ പ്രോസിക്യൂഷൻ കേസിലും പ്രോസിക്യൂട്ടർ അല്ലെങ്കിൽ പോലീസുകാർ ശ്രദ്ധിക്കാത്തൊരു പ്രൊവിഷനാണ്. ഇത് വെച്ചാണ് പലപ്പോഴും കേസ് ചെയ്തതും ആർഗ്യൂ ചെയ്യുന്നതും. So the law clearly says that the presumption is that what was fed into the originator was the one that was received by him. But the section again says, but there shall not be a presumption that it was sent by a particular person. Court shall not make any presumption as to the person by whom such a message was sent. കാരണം എന്താണത്? ഇപ്പം ഞാനിവിടെ ക്ലാസ് കൊടുത്തുകൊണ്ടിരിക്കുമ്പോഴേ ഷ്യാമിന് ഒരു കുസൃതി തോന്നി. ഇതെടുത്തിട്ട് ഏതെങ്കിലും ഒരു ലേഡി അഡ്വക്കേറ്റിന് ഒരു മെസ്സേജ് അയച്ചു. കേസ് വരുമ്പോൾ എന്ത് പറ്റും? ഞാൻ പ്രതിയാവും. കാരണം എൻ്റെ കയ്യിൽ നിന്ന് അയച്ചിരിക്കുന്നത് ഇല്ലേ? എൻ്റെ കയ്യിൽ നിന്ന് അയച്ചിരിക്കുന്നത് നമ്പറും എല്ലാം എൻ്റെ തന്നെ. ചെല്ലുമ്പോഴേ മജിസ്ട്രേറ്റ് എന്നെ റിമാൻഡ് ചെയ്യും. സത്യത്തിൽ ചെയ്യാമോ? ചെയ്യാമോ? ഇല്ല. കാരണം എന്താണ്? The section itself says that there is no presumption as to the person who sent it because this can happen. ഞാൻ ഇവിടെ എത്തോണ്ടിരിക്കുമ്പോഴേക്ക് ശ്യാം എൻ്റെ ഇതിൽ അയച്ചു കൊടുത്തു. So there is no presumption as to the person who sent it. There is no presumption that I sent it. The only presumption is that what was fed into it was the one that was received there. അല്ലേ? അപ്പോൾ ഹോസ്റ്റൽ വാർഡനെ അയച്ചതെന്നുള്ളതിന് ഒരു പ്രിസംപ്ഷനും ഇല്ല. ദാറ്റ് ഹാസ് ടു ബി പ്രൂവ്ഡ് ബൈ ഇൻഡിപെൻഡൻറ്റ് എവിഡൻസ്. ഇതാണ് ഇനി പ്രോസിക്യൂഷൻ കേസിലൊക്കെ വരാൻ പോകുന്നത്. എൻ്റെ മെയിലിൽ നിന്ന് ആരെങ്കിലും എൻ്റെ കമ്പ്യൂട്ടറിൽ നിന്ന് പോയാൽ ഉടനെ തന്നെ എന്നെ പിടിച്ച് റിമാൻഡ് ചെയ്യാൻ പാടില്ല, എന്നെ പിടിച്ച് ശിക്ഷിക്കാൻ പാടില്ല. പിന്നെയോ ദ പ്രോസിക്യൂഷൻ ഹാസ് ടു ഫർദർ പ്രൂവ് ദാറ്റ് ഇറ്റ് വാസ് ഐ ഹൂ സെൻഡ് ഇറ്റ് ബിക്കോസ് ഇറ്റ് ക്യാൻ ബി യൂസ്ഡ് ബൈ എനിവൺ. മനസ്സിലായല്ലോ? ദേ ക്യാൻ പ്രൂവ് ദാറ്റ് ഇറ്റ് വാസ് ഇൻ മൈ എക്സ്ക്ലൂസീവ് യൂസ് ആൻഡ് വൺസ് ദാറ്റ് ഈസ് പ്രൂവ്ഡ് ദെൻ സെക്ഷൻ 106 ഓൾഡ് വിൽ അപ്ലൈ because it is a matter within my special knowledge. Okay?
അതിലൊരു ചെറിയൊരു ബുദ്ധിമുട്ടുണ്ട്. കാരണം എന്താ വെച്ചിട്ടുണ്ടെങ്കിൽ മൈ ഇമെയിൽ ഐ ഡി ഹാസ് ഗോട്ട് ഇറ്റ്സ് ഓൺ പാസ്വേഡ്. ദാറ്റ്സ് ഓൺലി നോൺ ടു മീ.
അല്ല, പാസ്വേഡ് ഇല്ലാത്തതാണെങ്കിലോ?
ഇല്ലാത്ത വാട്ട് യു സെഡ് ഇസ് കറക്റ്റ്.
യെസ്, പാസ്വേഡ് എനിക്ക് അറിയാമെങ്കിലോ?
Yes. So
that is true.
It comes in the exclusion clause wherein my privy to that
exclusive knowledge.
Right to that is true. പക്ഷേ ഇതും കൊണ്ട് മാത്രം അങ്ങ് ചെന്ന് കഴിഞ്ഞാൽ കിട്ടുമോ? ഇമെയിൽ ഉണ്ടെങ്കിൽ എന്ന് വിചാരിക്കാം, എനിക്കറിയാം പാസ്വേഡ്, അങ്ങനെയൊക്കെ ഉണ്ടെങ്കിലോ? അല്ലേ? അപ്പം അതെല്ലാം കണക്കാക്കിയിട്ടാണ് ഈ പ്രൊവിഷൻ ഉണ്ടാക്കി വെച്ചിരിക്കുന്നത്. വന്നോളൂ.
അല്ല, അതിനും ഒരു പ്രിസംപ്ഷൻ ഉണ്ട്. യു ആർ സപ്പോസ് ടു ടേക്ക് കെയർ ഓഫ് യുവർ ഡിവൈസ്. ജസ്റ്റ് ലൈക്ക് ത്രോയിങ് ദ കീസ് അറൗണ്ട് ആൻഡ് സേയിങ് ദാറ്റ്
ശരിയാണത്.
യു ഗോട്ട് എ റെസ്പോൺസിബിലിറ്റി. യു കനോട്ട് റൺ അവേ ഫ്രം ദാറ്റ്. Practical, it's correct. But the presumption would be there because you got exclusive control over that computer network.
അപ്പോൾ 106 വരുന്നത്.
അപ്പോൾ you go to the general presumption.
സർ 106 പോകും. എക്സ്ക്ലൂസീവ് നോളജ്. ഓഫീസിന്റെ പ്രശ്നം ഇത് തീർച്ചയായിട്ടും ഇത് വരും. കവർ ചെയ്യും. പക്ഷെ അതുവരെ വെയിറ്റ് ചെയ്യണ്ടേ? അവിടെയാണ് പ്രശ്നം വരുന്നത്. അല്ലാതെ മിയർലി ബിക്കോസ് ഇതാണ് ഷാൻസ്വാമിയുടെ കേസിൽ ഇത് തന്നെയാണ് സംഭവിച്ചത്. ദ ഇന്റർനാഷണൽ മീഡിയ റിപ്പോർട്ടഡ് ദാറ്റ് ഇറ്റ് വാസ് ഇൻസേർട്ടഡ് ലേറ്റർ. മനസ്സിലായല്ലോ? ഇറ്റ് വാസ് സെൻഡ് ബൈ ഹിം, സോ ദാറ്റ് വാസ് ദ ഓൺലി എവിഡൻസ് അഗേൻസ്റ്റ് ഹിം. ബട്ട് ദി ഇന്റർനാഷണൽ മീഡിയ റിപ്പോർട്ടഡ് ദാറ്റ് ഇറ്റ് വാസ് ഇൻസേർട്ടഡ് ബൈ ദ പോലീസ് ഇൻ ദി ലാപ്ടോപ്പ് ഓഫ് ദിസ് പർട്ടിക്കുലർ priest. By that time he died. Yes. So these are all practical difficulties. We may face more practical difficulties later.
Moreover, there is a possibility that somebody can decode the password.
That of course. End of
ഒരു കാര്യം എപ്പോഴും
will be no end to it.
ഒരു കാര്യം എപ്പോഴും ഓർക്കുക, ഇതിൻ്റെ അകത്ത് എഡ്യൂക്കേഷൻ ക്വാളിഫിക്കേഷൻ ഈസ് ഇറലവൻറ്റ്. ഈ ടെക്നോളജിയിൽ നമുക്കറിയാലോ, നമുക്ക് കേരളത്തിൽ ഒരു ബാങ്ക് വൈകുന്നേരം ടാലി ചെയ്യാൻ നോക്കിയിട്ട് ATM-ലുള്ള പണവും അക്കൗണ്ടിലുള്ള പണവും ഒത്തുപോകുന്നില്ല. ഈ പറയുന്ന പണം, അക്കൗണ്ടിലുള്ള പണം ATM-ൽ എങ്ങനെ ഇത് സംഭവിച്ചു നോക്കിയിട്ട് ഒരു പിടിയില്ലത്. അവസാനം CCTV വെച്ച് നോക്കിക്കഴിഞ്ഞപ്പോൾ ഒരു കാര്യം മനസ്സിലായി. കൊല്ലം മുതൽ ചേർത്തല വരെയുള്ള ഈ ബാങ്കിൻ്റെ എല്ലാ ബ്രാഞ്ചസിൽ നിന്നും പണം പോയിട്ടുണ്ട്. പിടിച്ച് ആരാന്നറിയാൻ വിളിച്ചത്? ഹരിയാനയിൽ നിന്നുള്ള 18 വയസ്സ് പോലും പ്രായപൂർത്തി, അത് ഇലക്ട്രോണിക്കിൽ ഒരു വൈദഗ്ധ്യം ഇല്ലാത്ത 2-3 ചെറുക്കന്മാർ. അവരെ ഒരു കാര്യം മനസ്സിലാക്കി. എന്താ മനസ്സിലാക്കിയത്? നമ്മളൊക്കെ ഇപ്പോൾ കണ്ടിട്ടുണ്ട്, ATM-ൻ്റെ വാക്ക് എഴുതി വെച്ചിട്ടുണ്ട്, നിങ്ങൾ ക്യാഷ് എടുത്താലും ഇല്ലെങ്കിലും അക്കൗണ്ടിൽ നിന്ന് പോകും. നിങ്ങൾ കാശ് കളക്ട് ചെയ്താലും ഇല്ലെങ്കിൽ. പക്ഷെ പണ്ട് അങ്ങനെ ആയിരുന്നില്ല. നിങ്ങൾ 10 കറൻസി നോട്ട് പുറത്തേക്ക് വന്നു കഴിഞ്ഞാൽ നിങ്ങൾ എന്ത് ചെയ്യും? ഒരെണ്ണം അവിടെ വെച്ചിട്ട് 9 എടുത്ത് പോക്കറ്റ് ഇടും. ഈ ഒരെണ്ണം ഒരു പർട്ടിക്കുലർ പീരീഡ് കഴിഞ്ഞാൽ എന്ത് ചെയ്യും? തിരിച്ച് അങ്ങോട്ട് പോകും. അങ്ങോട്ട് പോയാൽ എന്ത് ചെയ്യും? എൻട്രി വിൽ ബി റിവേഴ്സ്. മനസ്സിലായല്ലോ? ഈ ഇൻസിഡന്റിന് ശേഷമാണ് ബാങ്കുകൾക്ക് മനസ്സിലായത് ഇങ്ങനൊരു സംഭവം ഉണ്ടെന്ന്. പക്ഷെ അതിനു മുമ്പ് ആര് മനസ്സിലാക്കി? ഈ പയ്യന്മാർ മനസ്സിലാക്കി. മനസ്സിലായല്ലോ? അപ്പം നമുക്ക് ഈ ടെക്നോളജി എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ ഇതിൻ്റെ അകത്ത് എഡ്യൂക്കേഷൻ ക്വാളിഫിക്കേഷൻ ഒന്നും വലിയ കാര്യമൊന്നുമില്ലത്. ആർക്കും മനസ്സിലാക്കാവുന്ന മിടുക്കന്മാരാണെങ്കിൽ. യെസ്
സർ, ഒരു ക്വസ്റ്റ്യൻ ഉള്ളത്, അതായത് ഒരു കേസിൽ കംപ്ലൈനന്റ് ഒരു 1 മന്ത്, ഒരു ഇൻസിഡന്റ് കഴിഞ്ഞ് ഒരു 1 മന്തിന് ശേഷം CCTV-യിലുള്ള വിഷ്വൽസ് CD-യിലാക്കി 65B-യുടെ കംപ്ലൈന്റ് ഫയൽ ചെയ്യുന്നു. പക്ഷെ ഫർദർ എൻക്വയറിയിൽ ഇൻവെസ്റ്റിഗേഷനിൽ പോലീസിന് പെർട്ടിക്കുലർ CCTV കണ്ടെടുക്കാൻ പറ്റുന്നില്ല. അങ്ങനെയാണെങ്കിൽ ആസ് എ ഡിഫൻസ് ലോയർ എന്തൊക്കെ ഒബ്ജെക്ഷൻ അതിനകത്ത് പറയാൻ പറ്റും?
അത് സർട്ടിഫിക്കറ്റ് ഈസ് ദെയർ. it is as good as the original. It is as good as the...
The problem with that, this has come in another case also. ഇത് ഓവർറൈറ്റിംഗ് ഉള്ള ഒരുവിധം എല്ലാ CCTVയും 60 days അല്ലെങ്കിൽ ഒരു പെർട്ടിക്കുലർ പീരീഡ് കഴിഞ്ഞാൽ ഇറ്റ് ഗെറ്റ്സ് ഓവർ റിട്ടൺ. സോ ആസ് എ പ്രൂഡന്റ് പേഴ്സൺ ഹു വാണ്ട് ടു റിലൈ ഓൺ ദാറ്റ് ഷുഡ് ഫസ്റ്റ് മേക്ക് എൻ ആപ്ലിക്കേഷൻ ആൻഡ് ആസ്ക് ദാറ്റ് അതോറിറ്റി ടു പ്രിസർവ് ഇറ്റ്. മറ്റ് ഇതാണോ അല്ലയോ എന്ന് കമ്പാരിസൺ കിട്ടാണ്ട് ഈ സർട്ടിഫിക്കറ്റിനെ കൊണ്ട് മാത്രം കാര്യം ഉണ്ടാവാൻ സാധ്യതയല്ല. വൈ? ബിക്കോസ് യു ആർ നോട്ട് ഇത് ഒന്നാമത് ആ പ്രോസസ്സിൽ നമ്മളില്ല certification and there is nothing to compare if it's being challenged, and what is being done by the certificate is only admissibility, not the proof of contents. Proof of contents specifically challenge vandണ്ടെങ്കിൽ you have to go to the primary source. If the primary source disappears and if that could have been prevented and you didn't take that step, this might become irrelevant. This cannot be
മൂവിയാണെങ്കിൽ that is a subject to conditions. Conditions എന്തൊക്കെയാണത്? Before it was overwritten, it was obtained. ഇല്ലേ? ഇതെല്ലാം പ്രൂവ് ചെയ്യേണ്ടത്. ഇത് പല കേസിലും ഇപ്പോൾ ഈ സംഭവിക്കുന്നുണ്ട്. കാരണം വെച്ചിട്ടുണ്ടെങ്കിൽ ഡിലേ വന്നു കഴിഞ്ഞു, ഡിലേ വന്നു കഴിഞ്ഞാൽ സ്റ്റിൽ യു ഗെറ്റ് എ കോപ്പി സംടൈംസ്.
അതിന് ഇപ്പം നമ്മൾ സ്പെസിഫിക് ആയിട്ട് വി ആർ ഫയലിംഗ് അപ്ലിക്കേഷൻസ് ഇൻ കോർട്സ് ഫോർ എ ഡയറക്ഷൻ. ആദ്യം നമ്മൾ റിക്വസ്റ്റ് കൊടുക്കും റിട്ടേൺ ഇറ്റ്. അപ്പം യൂഷ്വലി അവർ റിട്ടേൺ ചെയ്തില്ലെങ്കിൽ ദേ ആർ ഓൾസോ പ്രിവി ടു ദാറ്റ്. പാർട്ടിസിപ്പസ് ക്രിമിനൽസ് എന്നാണ് അതിനെ വേർഡ് യൂസ് ചെയ്തിട്ടുള്ളത്. എന്നിട്ട് യു ക്യാൻ ഗെറ്റ് എൻ ഓർഡർ ഡിവോഴ്സ് ഓൾ അതർ കംപ്ലൈന്റ്സ് എക്സെട്രാ ഫോർ ദിസ് പെർട്ടിക്കുലർ പർപ്പസ് ഫോർ പ്രിസർവേഷൻ ഓഫ് എവിഡൻസ് ആൻഡ് ഗെറ്റ് ഇറ്റ് പ്രിസർവ്ഡ്. മറ്റെല്ലാം പറ്റുന്ന വെച്ചിട്ടുണ്ടെങ്കിൽ 65B or whatever the new name 63 does not sanctify it. ഞാൻ നേരത്തെ ഫസ്റ്റ് തുടങ്ങിയ പറഞ്ഞ എക്സാമ്പിൾ, ഒരു കോടതിയിൽ ഹാജരാക്കിയിട്ടുള്ള ഒരു ഒസ്യത്ത് കള്ള ഒസ്യത്താണെന്ന് തെളിയിക്കാൻ ഞാൻ ഹാജരാക്കിയ ഒസ്യത്ത്, അതിന്റെ സർട്ടിഫൈഡ് കോപ്പി എടുത്താൽ ഒസ്യത്ത് വിൽ നോട്ട് ബിക്കം നല്ലത്. ഇറ്റ് ഈസ് ഓൺലി
ഒറിജിനൽ സ്റ്റിൽ ബാഡ്. എ കോപ്പി വിൽ നോട്ട് ബി എ ബെറ്റർ ദാൻ an original one. Yes.
റെക്കോർഡ് ചെയ്തു. അതിപ്പോ എന്റെ മൊബൈലിലുള്ള റെക്കോർഡിംഗ് ഈസ് വിത്ത് മീ. Someone else wanted to capture me, so they cannot access my phone normally. But they had a chance to get my phone. So they opened the phone, played that video and recorded it with their phone. What will be the evidence?
ഇത് വലിയൊരു പ്രശ്നമാണിത്, എസ്പെഷ്യലി ഇൻ ദ കേസ് ക്രിമിനൽ കേസസ്. കാരണം അക്യൂസിനോട് പ്രൊഡ്യൂസ് ചെയ്യാനായിട്ട് പവറില്ല.
സെൽഫ് ഇൻക്രിമിനേഷൻ പറയും.
നോ ഡൗട്ട്. ഏക മാർഗം എന്താണ് പിന്നെ സുപ്രീം ഇതിൻ്റെ അകത്ത് പറയുന്നത്? സീസ് ഇറ്റ്. ഇഫ് ദ പോലീസ് സീസസ് ഇറ്റ്, ഓക്കെ, ദേ വിൽ കം ഇൻ ടു കസ്റ്റഡി ഓഫ് ഇറ്റ്. അതർവൈസ് ഹൗ ഇസ് ഇറ്റ് പോസിബിൾ? ഇമ്പോസിബിൾ.
പിന്നെ in the case you mentioned, like any other piece of evidence, it has to be independently proved. അത് പറ്റുമല്ലോ. അതിനിപ്പോ ഈ പറഞ്ഞ 65B ഒന്നും പ്രശ്നം വരുന്നില്ല. കാരണം it is yet another piece of evidence
only.
That could be by reducing many ways and means of proving it ഉള്ളതിൽ കൂടി ചെയ്യാൻ പറ്റുന്നതാണ്. Once it is proved and probabilized,
we should not be under the impression that when there is an electronic record, that is the only evidence.
That is not the end of all, because this is a species of evidence and that is available, and all the regular law applicable for proving something is there. Over and above that ഉള്ളതാണ് ഈ പറയുന്നത്.
Yes.
Hi sir. So I had a question, especially on explanation 6 of section 57. So sir, our example പറഞ്ഞിരുന്നു, വീഡിയോഗ്രാഫ് യൂട്യൂബിൽ സ്ട്രീം ചെയ്യുമ്പോൾ 5 രാജ്യത്ത് നിന്ന് 5 പേര് കാണുന്ന ഒരു എക്സാമ്പിൾ പറഞ്ഞിരുന്നു. അപ്പോൾ അവിടെ സൈമിൾട്ടേനിയസ്ലി സ്റ്റോർഡ് എന്നാണ് പറയുന്നത്. പക്ഷേ ഒരു ലൈവ് സ്ട്രീം ഞാൻ ഫോണിലോ ലാപ്ടോപ്പിലോ കാണുമ്പോൾ സൈമിൾട്ടേനിയസ്ലി സ്റ്റോർ ചെയ്യുന്നില്ല. റാദർ I would be, if I want it for evidence, I will be downloading it later. So would that still come under the purview?
Stored, see, simultaneously broadcast or transmitted, not stored.
അപ്പോൾ ആ ബ്രോഡ്കാസ്റ്റിന്റെ സ്റ്റോറേജ് will be
മനസ്സിലായല്ലോ. സർ, അത് ഏതിനോട് ചേർത്ത് വായിക്കണം എന്നുള്ളതാണ് അതിൻ്റെ അകത്ത് ചോദ്യം വരുന്നത്.
What is being certified is the process of what is being produced. So if it is a printout, the process of printout is what is necessary.
Sir, I had a doubt, sir. So with regard to the
video recording is simultaneously stored in electronic form and transmitted and broadcast. അല്ലേ, അവിടെ അങ്ങോട്ട് പോകുന്നു, ഇവിടുന്ന് അതാണ് പറഞ്ഞിരിക്കുന്നത്.
So with regard to the example that was cited earlier with regard to the email, sir, with regard to the example that was cited earlier with regard to the proof of email, so I would like to raise a doubt that as per section 11 of the IT Act, sir, there's a presumption that I think the wording is that the the electronic record can be only attributable if it is sent by the originator himself. So what is the effect of that particular provision with regard to when it's played in comparison with section 106 of the Evidence Act?
106.
Yeah. So because there is a burden of proof in 11 of the IT Act that would say that an electronic record can only be attributable to the originator if it is sent by the originator himself.
The point of the material entering the computer network, if it is in your sole custody or reasonably expected to be in your custody, the presumption is that it is you. Then it is for you to rebut that it's not me, where office mail.
Yes, sir.
The burden or the onus is on me.
But the word used in section 11 is sent by the originator himself. Sent is an act.
By the original. So you have to prove that it was sent by the.
So section 11
you
section
say.
11 of the IT Act.
IT Act.
IT Act in section 11 would say that an electronic record.
I have to study it.
Yes, sir. Section.
Do you have section 11? Can you just read it? To my understanding, to my understanding, once it enters a computer network and then it is out of custody of the other person, and whoever was in custody or reasonably expected to be in charge of that.
Sir, I shall read it, sir. Section 11.
Anybody can just read it out. Please.
Attribution of electronic records.
Yes.
An electronic record shall be attributed to the originator. A. If it was sent by the originator himself. B. By a person who had the authority to act on behalf of the originator in respect of that electronic record. Or C. By an information system programmed by or on behalf of the originator to operate automatically.
What is the...
Sent by the originator himself.
So
the question of fact.
That's my question.
Question of fact.
Yeah, that's my question.
There's no conflict between these two provisions.
So can there be a presumption is my question.
No. Presumption arises, always remember, presumption arises only when you prove that basic facts.
Yes, sir.
What is the basic fact here?
Original.
Yes, sent by the originator.
Originator himself. Exactly.
And
that fact has to be proved first.
Cautiously worded originator.
Originator, exactly.
Yes. Whoever it might be.
Yeah, exactly. Originator.
Yes.
Not the party or not the owner or the whose email ID, nothing. It's the originator.
No. Correct. Thank you.
Okay.
Sir, I think my question can be more effectively answered by Shyam sir, because Abraham Mathew sir already put a caveat that he doesn't have exposure to those kind of new technology. Suppose a person publishes something defamative through his WhatsApp status, which can be seen to everybody else. So how can we use that publication?
The essential elements of defamation is proved. That is creation and publication and circulation.
Yes.
That is done. And he does it with the knowledge that it will be seen by others. Then
Yes.
what remains is only how and this evidence can be produced.
Evidence can be
So it is exhibited, his status will be seen in every person's, even in news. Status screenshot of that can be taken and with a certificate saying that it's from my mobile, that the particular and again it's only admissibility and proof is something entirely different. Let us not confuse or conflate the two. So that's the only way you can bring it out. And if you can file a police complaint and like sir Varnamari, it being an incriminating material because it's a criminal offence also. It can be seized also.
No, that the proving the originator would be difficult there because
that's something different. The earlier one was putting into network, etc. Here you can show that it is being published and it is being circulated by him by means of putting it in his status. A status eppo mane maatavunnaanu. Appo aa kudi namakku cheyan pattunnathu then and there adinte screenshot edukkanallu maatrame ullu.
Status every 24 hours it automatically goes.
Correct. Then it's only a question of fact like any other fact. You produce it just as a material object. It has got nothing to do with IT Act. അല്ലാതെ കോടതിയിൽ എങ്ങനെയാണോ തെളിയിക്കുന്നത് അതേമാതിരി തന്നെ തെളിയിക്കേണ്ടി വരുന്നത് ബൈ എഡ്യൂസിങ് എവിഡൻസ് ബൈ ഓറൽ എവിഡൻസ് ആവാം അല്ലാതെ ആവാം അല്ലാണ്ട് തന്നെ ടെക്നോളജി വെച്ചിട്ട് എനിക്ക് ദാറ്റ് യു ഹാവ് ടു എൻക്വയർ വെദർ ഇഫ് ഇറ്റ്സ് പോസിബിൾ ടു ബി റിട്രീവ്ഡ് ഫ്രം ദ സ്റ്റാറ്റസ് ദാറ്റ് ഇഫ് ഇറ്റ് ഇസ് പോസിബിൾ then it can that also can be thought of.
Thank you, sir. Yes.
Last two questions. Meena first.
First of all, thank you so much, Wednesday Club, for this very insightful session. It was much needed. So my question is something that Shyam Padman sir has already discussed in regard to the production of the screenshots as evidence. So if the chat is deleted as a whole and there are only screenshots, so I have read some judgments where these screenshots have been totally rejected for technical metadata grounds. So how can it comply with the requirements of section 63(4)?
For a second, if you forget that it is anything to do with IT Act, it is yet another piece of evidence that can be, if proved otherwise, forget about the technology and techniques behind it, it can be. Otherwise, there is a problem because then the authenticity and attribution, attributability, etc., there will be issues governing that because there is nothing to relate it back to the originator. There is a problem. But otherwise, like the doubt expressed by my friend also, that is an independent evidence. If it can be proved otherwise, it can be by even witnesses. There is nothing wrong in that. Please be wrong. Let us not be under the impression that IT Act is the end of all. If anything that is electronic, etc., just because it has got anything to do with electronics or web-enabled technology, all other things, it is in addition to and not in derogation to the other rules or procedures available for proving anything. So, end of the day, it's a proving a fact that can be proved.
Last question, sir. So when we produce WhatsApp, am I audible now? Yes. So if I want to produce certain WhatsApp messages as evidence, so I think the challenge faced is on top of it, if you can in fact delete a person's name and add a number if you want to. So this is a big challenge. So from your point of view, both your point of view, how can I effectively produce a chain of WhatsApp conversations in evidence if it contains some obscene messages or something in violation of law?
It has been received in your mobile. Now it is end-to-end encrypted.
Yes.
There is an option available if you go to the settings wherein export chat. So whatever changes made in between like number etc. will be reflected in the export chat. So the entire chat history will be exported and that can be because there is no way it can be manipulated. So it can be produced and whatever he can take up a defense saying that it's not mine etc. that is to be met otherwise. But protection of WhatsApp messages is easy because now every message is end-to-end encrypted. So there is no possibility of any compromise in between or in transit. And if you take this as export chat without any human intervention, whatever is available in the chat, including media, can be exported.
So,
that can be produced.
The export chats have to be furnished along with the 65B 63.
What else can, if you are producing your mobile itself, no 65B is necessary because it's original in itself.
Yes.
So if you are producing the chat, 65B is necessary, saying that it is from my mobile it has been taken.
Yes. Thank you.
Okay, I think we can wind up. I have to go.
Now I
have
invite.
to go to Trivandrum tomorrow early morning. So I have to rush.
Now I invite Advocate Abin Thomas to give the vote of thanks.
Hello. Hello. Yeah. Good evening, everyone. So, an apt quote to explain what technological progress is can be taken from the movie Avengers. I'll just paraphrase it a bit. Dread it, run from it, but technology still arrives all the same. So in that scenario, obviously you can always resist it, like the Shirastha story that K.Abraham Mathew said. But rather, at the end of the day, we lawyers have two options. We can either adapt or be obsolete. And this process of adapting to changing technology, it's not just individual, right? It comes from an environment of education. You need institutional support for that. You need senior jurists to advise you along the way, and you need a group of peers to push you to become a better lawyer. And In that note, I would like to extend my thanks to both our distinguished speakers, Justice Abraham Mathew and Senior Advocate Shyam Padman sir. Two brilliant minds who reminds us what it means to be a learned jurist by constantly adapting your your stream of knowledge. I extend my gratitude on behalf of the Wednesday Club for taking time out of your busy schedules for today's session. I would also like to thank the KHCAA Executive Committee, especially the Secretary Advocate Nima Jacob for facilitating today's session, and the program coordinators for the Wednesday Club, Advocate Subeesh, Advocate Anchala, Advocate Ruben. I would extend my gratitude to all of them. I would also extend my thanks to the research team, Advocate Fabi, Abdul, Latheef, Advocate Swetha, Advocate Meena, Prakash, Advocate Nadiya, KM. Also to Advocate Ashwini, who had designed the poster. I would extend my thanks to everyone on behalf of the Wednesday Club. And finally, on a personal note, I would also like to thank the person who decided to bring the notebook for everyone, because I had forgotten my notebook and I was just wondering if someone had a notebook and they gave it to me. So that's just me on my personal behalf. Thank you.